First Amendment is only 45 words long, covering 2 lines in the original handwritten copy of the Bill of Rights. Despite its short length, the amendment is a cornerstone of the nation's liberty. Today in this video, we're going to look at what 5 fundamental freedoms does the First Amendment protect, and what are the guarantees and limits of the First Amendment. In the First Amendment, it outlays the freedoms that Americans cherish above all others. With few exceptions, government cannot tell you what to believe in matters of religion, what you may or may not say, what the press may write or publish, or with whom you may gather. In short, the First Amendment gives us the freedom to live our lives as we see fit. Chief among the freedoms guaranteed by the First Amendment is the freedom of religion. Search for religious freedom was a central factor in the development of the U.S. The First Amendment guarantees religious freedom in 2 ways. First, it forbids the government from establishing an official religion. And the second, the First Amendment guarantees people's right to a free exercise of their own religion. As you can see in this clause, Congress shall make no law respecting an establishment of religion. This part of the First Amendment is known as the Establishment Clause. It declares that government can't take actions that create an official religion or support one religion over another. The idea behind the Establishment Clause was famously expressed by Thomas Jefferson. He cited that there needs to be a wall of separation between church and state. Now, while the First Amendment limits government support of religion, there's some disagreement about just how separated church and state should be. One issue the courts face under the Establishment Clause is the legality of government-sponsored religious displays. In Lynch v. Donnelly in 1984, for example, the Supreme Court evaluated a Rhode Island display that included both religious and non-religious symbols, such as a Christmas tree, a scene depicting Jesus' birth, and colored lights. The court decided 5-4 that the display did not intend to benefit a particular religion. Acknowledging religion, the decision said, does not necessarily mean the government is promoting it. In 2005, a divided Supreme Court issued 2 5-4 decisions about government displays of the 10 Commandments, which are part of the Christian and Jewish tradition. For example, in McCreary County v. ACLU of Kentucky, 2 courthouses displayed framed copies of the 10 Commandments. The Supreme Court deemed this unconstitutional because the government promoted a particular religious belief and it had no legitimate secular purpose. On the same day, however, the court's decision in Van Orden v. Perry, it allowed the display of the 10 Commandments at the Texas State Capitol. In Texas, the 10 Commandments were carved into a stone marker and were part of a larger display that included other markers representing aspects of Texas's history. Perhaps the strongest debate over the meaning of the Establishment Clause has to do with education. Everson versus the Board of Education centered on a New Jersey school district's plan to use public money to bus students' private schools. In a 5-4 decision, the court narrowly upheld the New Jersey plan, observing that the plan applied to students of all private schools. The court again tackled the issue of religion in public schools in Engel versus Vitale. New York school officials had written a prayer that public school students were asked to recite at the start of each day. The prayer was not based on any specific religion, and students were not forced to participate, but the court held that the prayer violated the Establishment Clause. The public debate over prayer in public schools continued today. The Supreme Court took up a case involving public support for religious schools in Lemon v. Kurtzman in 1971. In Lemon, the court struck down a law that allowed public funding for the teaching of non-religious subjects at private schools, including religious schools. In its ruling, the court established the so-called Lemon test for use in future Establishment Clause cases. According to this test, a law must meet all the 3 of the following standards in order to be found constitutional. It must have a secular or non-religious purpose, its major effects must neither advance nor inhibit religion, and it must not encourage excessive government entanglement with religion. First Amendment also protects freedom of religion through what is known as the Free Exercise Clause, which guarantees each person the right to hold any religious belief they choose. Simply put, the government can't tell a person what he or she must believe in matters of religion. The Free Exercise Clause does not give people a clear right to behave in any way they wish, however. For example, the Supreme Court found in Employment Division of Oregon v. Smith that government can punish illegal drug use even if the drug use is part of a religious practice. The Supreme Court first took on the issue of limiting religiously based behavior in Reynolds v. U.S. The case involved a Mormon religious practice that the faith now prohibits polygamy, or the marriage of a man to more than one woman. The court held that even though some Mormons saw polygamy as a religious duty, government could forbid it. In Wisconsin v. Yoder in 1972, the court heard a challenge to a state law requiring school attendance until age 17, which conflicted with Amish religious beliefs. The Supreme Court again found that the state interest in forcing school attendance was not strong enough to justify the law at the expense of religious beliefs. The First Amendment forbids Congress from making any law abridging freedom of speech or press, but courts have not treated these freedoms as absolute. The Supreme Court has ruled that government may place limits on freedom of speech and press, especially concerning issues of national security. In the U.S. system of government, decisions are made by representatives chosen by the people. If Americans are to make thoughtful decisions and participate fully in the democratic process, they must have access to a full range of opinions, beliefs, and information. They must also be able to discuss and criticize the government policies without fear of punishment. This principle of free political debate has led to the adoption of open meeting laws by states and the federal government. These laws generally require government bodies to debate and act in public rather than behind closed doors. Furthermore, under the Freedom of Information Act, the federal government must release government documents, except for certain secret or private records, to the press and the public upon request. Protecting freedom of speech and of the press is especially challenging in the case of unpopular ideas. Few people, for example, would agree with racist or offensive speech, and it would be relatively easy for government to outlaw such speech. Yet the First Amendment exists especially to protect unpopular ideas. While the First Amendment protects even unpopular ideas, it does have some limits. The ability to speak and to print ideas can be limited by government for a variety of reasons. For example, the government can limit speech or printed material that is judged obscene. The government can also regulate what businesses say about their products. False advertising, for example, can be outlawed. The Supreme Court has also ruled that the Constitution does not protect defamation or false statements about a person that causes harm to that person. A spoken defamatory statement is called slander, and defamation in print is called libel. Individuals who believe that they have been slandered or libeled may take legal action to defend themselves. In the landmark case New York Times Co. v. Sullivan in 1964, the Supreme Court ruled that public officials have fewer legal protections against libel than do private citizens. As with laws against slander and libel, the government may limit First Amendment freedoms in the name of national security, such as to prevent treason or sedition. Treason is the crime of making war against the U.S. or giving aid and comfort to its enemies. During wartime, certain speech or writings may be considered treasonous. For example, publishing information about the location or tactics of American forces that aids the enemy. Sedition is a legal term for speech or actions that inspire revolt against the government. Courts have upheld laws banning seditious speech. Attempts to define seditious speech and to analyze whether or not it has been protected by the First Amendment have caused controversy throughout American history. Let's look at a few examples. In 1798, the Federalist Party, which controlled Congress and the presidency, passed the Alien and Sedition Acts. It was intended to protect the country from domestic dissent during a war, but in reality, the new laws seemed designed to silence the Federalists' political rivals, the Democratic Republicans. Later on, during World War I, the Espionage Act and the Sedition Act were passed, which targeted criticism of the government and interference with the American war effort. In Schneck v. United States in 1919, the Supreme Court decided that speech can be limited if it creates a clear and present danger. The court continued to struggle with the clear and present danger standard in later years. At Whitney v. California in 1927, they felt that they had the power to punish those whose words might encourage crime, disturb the peace, or otherwise harm the public welfare. In World War II, Congress passed the Smith Act, which outlawed calling for the forceful overthrow of the U.S. Organizing or joining a group that held such views was also outlawed, and the Smith Act remains in force today. Just as the First Amendment protects the freedom of speech, it also protects the freedom of the press. This protection acknowledges the importance of a free media in a democratic society. The press is vital to the free spread of information and ideas. As with speech, government has tried to balance the need for media freedom, the rights of others, and issues of national security. Radio and TV broadcasters have fewer First Amendment protections than print media. Congress created the Federal Communications Commission, also known as the FCC, to carry out regulations. Under FCC rules, certain language and content are limited or prohibited. Because cable systems do not use public airwaves, they are given greater freedom than broadcasters. The internet is also less subject to government regulation. The government has tried to limit pornography on the internet, but this effort has been largely unsuccessful. In one case, Reno versus American Civil Liberties Union, in 1997, the Supreme Court rejected a law that sought to regulate internet pornography, in part because users are not likely to encounter offensive content by accident. Another issue related to the freedom of the press is prior restraint, or government action that seeks to prevent materials from being published. Consider the case of J. Neer, a Minnesota newspaper publisher in the 1920s, who printed articles accusing local officials of corruption. The state of Minnesota tried to stop Neer from publishing his paper. The Supreme Court ruled in Neer v. Minnesota in 1931 that prior restraint is almost always unconstitutional. Minnesota could punish Neer if he violated a law, but they could not prevent him from publishing his paper. The court addressed another case involving prior restraint in New York Times Company v. U.S. in 1971. President Richard Nixon tried to halt the New York Times publication of the Pentagon Papers. These were classified documents about the history of U.S. involvement in the Vietnam War. White House argued that publishing the papers would threaten national security and the peace process. In reality, the Nixon administration realized that publication would reveal that U.S. officials had long misled the public about the war. The court ruled that the government had failed to prove a need for prior restraint, and the papers were published. In general, the Supreme Court has granted some First Amendment protections to symbolic speech, or the communication of ideas through symbols in action. The court has held that some symbolic speech deserves protection, as long as the speech does not pose a major threat to property or public order. One particular important symbolic speech case was Tinker v. Des Moines Independent Community School District in 1969. The court ruled in Tinker that an Iowa school district could not prevent students from wearing black armbands to protest the Vietnam War. In the case Texas v. Johnson in 1989, the Supreme Court ruled that burning the American flag as part of a political protest was a protected act of free speech. Ruling stated, if there is a bedrock principle underlying the First Amendment, it is that government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. The First Amendment's final two protections prohibit government from denying people the right to peaceably to assemble and to petition the government for a redress of grievances. In other words, people have the right to meet together and express their views peacefully. This right ensures that Americans can share ideas with each other and make their own opinions known to their government, including through measures known as initiatives or petitions designed to force government to consider an issue or allow a vote. Still, there are limits to the rights of assembly and petition. The Supreme Court has affirmed the freedoms of assembly and petition in several major decisions over the years, including DeJong v. Oregon in 1937. The court found that Dirk DeJong had the right to speak at a peaceful public meeting held by the Communist Party, even though the party generally advocated industrial or political change and revolution. Edwards v. South Carolina in 1963 was another important case involving the rights of assembly and petition. This case involved a group of 187 African American students in South Carolina who had gathered to protest racial injustice in the state. Though the assembly was peaceful, local police told the students to leave the area, fearing that the crowd gathering to watch the protest might become violent. The Supreme Court of the U.S. held that the First Amendment forbade state government officials to force a crowd to disperse when they are otherwise legally marching in front of a state house. In general, government cannot limit the right of assembly and petition based on protesters' points of view. Only in extreme cases, such as protesters encouraging others to commit violent acts, does government have strong enough reason to limit this important First Amendment freedom. Government can more easily limit the right of assembly and petition for reasons other than the ideas expressed by protesters. For example, governments can place reasonable restrictions on the time, manner, and place of gathering. Courts have found, for example, that citizens can be required to obtain a permit for holding a demonstration. They can be denied the right to make excessive noise. They can be kept off of private property or prevented from invading the privacy of others. But any such rules must serve a clear and valid purpose, and government must apply them evenly and without regard to the content of the demonstrator's message. The phrase freedom of association does not appear in the First Amendment. Still, the Supreme Court has determined that the freedoms guaranteed by the amendments together establish the right to freedom of association, the right to join with others, share ideas, and work together for a common purpose. As you can see, the First Amendment is pretty important, so what I'd like you to do is think about these following questions. Why do you think so many questions of religious freedom have involved schools and public education? What might happen if the freedom of speech and of the press were rights that can never be restricted or limited by the government? Do you think it's important to keep church and state separate? Why or why not? And lastly, do you think in times of war or an emergency that government should be able to place greater limitations on our freedoms? Why is that? Thanks for watching, and as they say in my hometown, don't forget to be awesome.